A very warm welcome to all of you, ladies and gentlemen, distinguished guests, and legal enthusiasts. I, Paras Chuk, a member of Legal Vidya, welcome you all in the session on how to do legal research with Legal Vidya, and it's a pleasure to be your host for this enlightening session. First of all, congratulations to all of you selected as a research interns for the March month. Before we delve into the details of this workshop, let me take a moment to introduce Legal Vidya to you all. It is founded in 2021. Legal Vidya, where the legal journey to you all begins with a flourish. More than just a platform, Legal Vidya is the compass guiding law students through a realm of boundless opportunities. It has been a beacon of knowledge and guidance for individuals interested in the field of law. It has consistently striven to create a platform where legal enthusiasts can nurture their passion, enhance their skills, and prepare themselves for a successful career in the legal profession. It is not just a platform, it's a rendezvous with your legal aspirations. Now, let me introduce to our distinguished speaker, Miss Sakshi Sharma. She is the founder of Legal Vidya. She is a dynamic legal professional who has dedicated herself to the empowerment of aspiring lawyers and legal enthusiasts. With a profound passion for legal education, Sakshi ma'am has tirelessly worked to bridge the gap between academia and practical legal skills. Her commitment to nurturing the next generation of legal minds is evident through Legal Vidya's innovative webinars, workshops, and educational initiatives, which aim to provide invaluable insights into the legal profession. Sakshi Sharma Ma'am's visionary leadership has made Legal Vidya a cornerstone in the journey of countless individuals seeking to excel in the field of law. I would like to request you all to please keep your mic on mute and keep your video off during the session. And if you have any questions, please ask them at last when the speaker will ask you to do so. Here in this session, get ready for a legal research adventure. We are diving into the captivating world of legal intricacies, unlocking the secrets of research, unleashing our creativity in legal writing, mastering the art of citation, the boldly facing the plagiarism challenge head on. Let the legal exploration begin. Together, we can learn, grow, and contribute to the ever evolving landscape of the legal field. Thank you, and let us begin. Over to you, ma'am. Please, ma'am.
Thank you so much, Paris. Firstly, can someone confirm if I'm audible? You can just write it down in the chat box. Yes. So good evening, everyone. I'm Sakshi, and I welcome you all to this session on legal research and legal writing. I'll specifically focus on the articles that you will be writing for Legal Vidya during your tenure of internship, what all you should cover, and what are the bases that you must look at. Now, before I go any further, can someone tell me if I should continue in English or in Hindi or bilingual? Because I don't know which language most of you are comfortable in. Just write it down in the chat box, and whichever is the most, I'll continue in that language. Bilingual, both. Okay. So let's go with bilingual. I hope everyone is okay with that. Please tell me once my screen is visible. I'm just sharing it right now. Is it visible? Okay, great. So again, welcome to the session on legal research and writing by Legal Vidya. And this is an introductory session. We won't go into too much detail and too much, I'd say, a technicality of things, because if we do that, the session will go on for hours and even for days. Now, before we begin, since our topic is research and legal research, does anyone have an idea of what research is? If you haven't seen my PPT yet, just write it down, whatever you think what research is. What do you mean by research? What do you mean by legal research? Or what do you mean when we say ki we'll write a research paper? You can write it down in the chat box. Whatever your ideas, you don't need to give a specific definition. Just put the words together and we'll all figure it out together what research is. Articulating facts and information. Okay. Study of a particular topic, right? Anyone else on any other idea of what research is? Analyzing and understanding a concept, right? You're all right. Research basically is analyzing the already existing data and digging deep into it to find out new concepts or to explain the already existing concepts in a much more detailed manner to the reader. Okay, so that is what legal research is. Critically analyzing and addressing the research gap, yes. Now, why we do research? We do research either to gain knowledge on an existing topic or to find out new information or to find out loopholes in law. When we are talking of legal research, we talk of when we talk of law specifically, we say there are a lot of loopholes in law. That is why, say for example, there's criminal law. That is why criminals are roaming about free, because there is a lot of loopholes. To find those loopholes, to find out the lacunas in law, to find new concepts in law, to find out ways in what we can make law better, we do research. Now I'll share my PPT again. Just let me know once it's visible. I'll share my screen. If it's visible, tell me. Is it visible?
Yes, ma'am.
Great. Thank you so much, Paris. Thank you everyone who's here. Now, meaning. Research basically is investigation or experimentation aimed at discovery and interpretation of facts, revision of accepted theories or laws in light of new facts, or practical application of such new facts or revised theories or laws. I'm so sorry, I'm a little bit unwell. So basically what we do in research is we investigate the already existing facts, or we interpret the already existing facts and data that we have. And what we do is we investigate in the light of new knowledge. Now, I'm talking of most colleges in India. When you're in your final semester, that is 10th semester, you all will be given a task of writing a dissertation or thesis, right? Now, when you write the dissertation or thesis, you just do not take a topic that is already available, जिसमें बहुत ज़्यादा data net पे है, आप copy paste करके लिख दो, नहीं. You do research to find out something new and something much more, I'd say, something जिससे हमें change ला सके. Okay, to put it in simpler terms. जैसे for example, मैंने topic लिया था bail से related. Bail is, there's a lot of articles on bail. There's CRPC पूरा भरा हुआ है bail से related chapters है 436, 437, 438 when we talk of that time. Right, we have that. अभी अगर हम लोग आजकल की बात करें, we have the new criminal amendment laws जिसमें bail से related और भी बातें की गई है. You just don't write those things in your particular dissertation. You analyze them in light of the new facts that you're having. अब new facts क्या हो सकते हैं? New facts can be that the prison conditions are not good enough to keep prisoners for a long time, or the new facts can be that there's lacuna in laws due to which there are a lot of under trial prisoners. So what we do is we investigate on new facts and on new facts, or we discover new facts, or if there are already existing facts, or if there are already existing law, we try to see them in a new light to come up with a new research that is helpful for the society. So research is basically creation of new knowledge and or use of existing knowledge and or use of existing knowledge in a new and creative way, so as to generate new concepts, methodologies, and understanding. Now, if we read the second definition, it will make it clear why we do research. to generate new concepts or to create new methodologies or to make our understanding better. This is why we do research. Now, when we talk of legal research, it is basically done, as I've already stated, to address the lacunas in law or to find what are what are the things that can be made better. If we have, say for example, there's an X law and there are 10 to 15 lacunas. When we do research, we can come up with certain suggestions and certain techniques that we can use or that we can incorporate in our already existing law so as to ensure that the delivery of justice is made in a better way. Now, types. There are many types of research, but when we talk of law, we generally stick to 2 to 3 kinds. However, we'll be discussing all of them in brief here. The first is descriptive legal research. It delineates the current state of a phenomena, focusing on what has happened and what is happening without probing causation. In general terms, in 2 lines to explain it, what we do in descriptive legal research, we just outline the current state of the law. That is, we do not go into why the law is the way it is. We do not find a reason for the particular thing. Now, this method is often used to provide an overview of legal issues and to establish a baseline understanding or document existing practices without analyzing the underlying reasons. Basically, we have the concept with us. What we do is we just our research will just revolve around it. We do not see the reason for why the law is that particular way. Then we have analytical research. It critically examines existing facts and information to discern underlying patterns or implications, aiming to understand the deeper meaning behind legal phenomena. Now, when we talk of descriptive, it is just focused on what law is and not the reason for why it is like that. In analytical legal research, we go behind, we dig deeper to understand that what are the reasons behind the particular law and why a particular law is implemented for that simple reason. Applied legal research, it seeks practical solutions to real world problems operating within practical contexts to address pressing issues effectively. Now, applied legal research basically is used when the legislature is trying to make new laws or draft new regulations and new acts and regulations, because they have seen a particular law and how it is impacting the real world, that is the common people, say for in India, how it is impacting the general population. Now they use applied legal research to make laws in a manner that would solve the issues that the people are facing. Then we have fundamental legal research. It aims to advance theoretical understanding, focusing on expanding knowledge rather than immediate application, often contributing to development of legal theory. It is used by legal scholars and academicians like the jurists that we talk of, to develop an legal concept, an abstract legal concept, because if you have read jurisprudence, you might have seen there are a lot of theories in that particular subject, right? The concept of person, the concept of property, the concept of law itself, there are many various theories, and many various jurists have given different opinions. They use fundamental legal research where they use their understanding to develop a particular concept. And in this particular type of legal research, we do not focus on the immediate application of the particular law, but we focus on developing a legal theory. So, hence, it is used mostly by the jurist or with, say, legal scholars. Then we have quantitative legal research. It relies on numerical data. Quantitative is what? Quantitative is that we have a quantity, some particular data. So, we have some particular data or numerical data to measure and understand quantifiable aspects of legal phenomena. It is used mostly in kind of legal cases to assess the impact of changes in legislative changes in society. Now, say for example, there is the new criminal law being implemented. Okay, we want to see how it has impacted society. For that, the best way is to go to the society and ask them how they are being impacted. Now, when we do that, we'll have a numerical data, right? So, implication of that data is known as quantitative legal research. Then we have qualitative legal research. Opposite of quantitative is qualitative. Now, it explores the quality and characteristic of legal phenomena, employing methods like unstructured interviews and participant surveys to gain insight into subjective experiences and perception. Now, this is often used to explore complex social and cultural aspects of law, because law is not something that is bound within itself. It is not just law that we are focused on when we are lawyers or advocates. We also have to see how it is impacting the world and how it is impacting the society around us, right? So, to understand the experiences of the society around us, we use this particular type of legal research. Then we have conceptual legal research. It engages with abstract theories or ideas commonly used by philosophers to develop existing legal concepts, contributing to a theoretical framework. Simply put, used by jurists and used by legal philosopher or theorist to challenge a conventional legal thinking and to propose alternatives of the way we are already thinking. Then we have empirical legal research. It relies on observation and experimentation, utilizing data and facts to substantiate hypotheses, providing empirical evidence to support or challenge legal theories or practice. Now, when it is used, this is often used to test a particular hypothesis, to evaluate the effectiveness of the legal interventions that you're doing, or to assess the impact of legal reforms in a society. We use empirical legal research. Then we have the last two and the most commonly used ones, doctrinal legal research and non doctrinal legal research. Now, doctrinal legal research is something that is also known as a library based legal research method. Why? Because you're only using your books, your cases, your journals that are available, the material that are available in library. So basically, आप एक जगह बैठ के रिसर्च कर रहे हो, जैसे मान लो कि अभी हम आपको कोई टास्क देंगे, राइट, टू राइट अ लीगल रिसर्च आर्टिकल. You won't go around doing surveys. You won't go around seeing or meeting 1,000 people for writing your research article. What you'll do, you'll refer to textbooks, you'll refer to case laws, you'll refer to statutes, you'll refer to the principles and the materials that you already have via internet or your library. So that is what doctrinal legal research is. It is basically a type of research where you do not get out of your comfort zone. You just sit there and research on the already existing material, gather it, and come up with your conclusion. We are only concerned on what law is in doctrinal legal research method. We're not concerned about why law is the way it is or how it is impacting society or what can be done to make it or what are the lacunas. We are only concerned about the law and how it is. Then we have non-doctrinal legal research. Non-doctrinal legal research is an interdisciplinary research because law is not something that is constrained to itself. As I've already said, it affects the society. Law is made for the general population, that is, law is made for the citizens of a country. So non-doctrinal legal research is used when we want to know how law is impacting the population. Now we use sociological, anthropological, historical analysis, and many other types of perspectives and many other types of, I'd said, disciplines to explore a legal issue from a broader perspective. Now, what we do in this, we go outside, we take surveys, we make questionnaires and ask for their particular what I'd say, their particular opinions on a particular matter, collect data. So basically, opposite of doctrinal legal research, we go out, we find data, we find how a particular law is impacting people and generation and how it has been implemented. So we're not just sticking with library, but we are going out. So that is what non-doctrinal legal research is. uh, Now coming to steps to writing your research article. I have divided this into 4 criteria. Firstly, identifying your research question, then identifying your headings and subheadings. Then we have making a rough and filling information and revision and editing. Now these are the 4 steps to writing your particular research article, or even when you're writing your research paper. These are the 4 steps that you'll mostly follow. The firstly, what is your research question? Now research question basically is the topic you want to write your research article on. Okay, so if you do not have a topic, say for example, we take the example of your dissertation itself. Okay, now say for example you do not have your topic. What you'll do is you'll try to find out what is the topic that you're interested in, because there's no use of going and delving into a topic that you're not interested in, because that will just again be forcing yourself to do something that you're not interested in. So always whenever you're trying to do a research, specifically when you're in your final semesters or when you're writing your research papers, try a topic which you're interested in. Okay, so choose that particular topic. Are there any other particular aspects or dimensions of this particular topic you want to explore, and how your research will contribute? Now, these are the 3 things that you need to understand while you're writing your research paper or research article. Now, firstly, you cannot start writing your article if you do not have an idea of what the topic is. How do you understand what your topic is? Go on Google. Now we have the luxury of Google, right? Because जब Google नहीं था तो हमारे जो फैकल्टीज थे, हमसे जो पहले की जनरेशन थे, वो तो लाइब्रेरी में बैठ के पढ़ते रहते थे. But now we have luxury of Google. Now we have tools that help us understand the particular topic. So I'm not saying use tools for writing your article. I'm saying to understand the topic, you can use AI tools, not for writing on your topic. Please don't confuse the two. Now, use those tools if you're not able to understand your topic, or go on Google, write a particular topic. There'll be thousands of articles on that particular topic. Go through it, read it, and then you'll have an understanding on what your research question is. Once you have that understanding, you can then develop your article. Now, when we talk of writing research paper, you cannot write research paper without a motive. Now, if we're talking about an article that you have to write in your internship, you'll be given a topic and you'll have to write on that, right? But when we're talking of a research paper, since we're not just taking ourselves with the internship point of view, we're also talking of a research paper. You cannot write a research paper without without addressing a specific issue, or without bringing any new aspects of law into consideration. So always first find out your area of interest, then see what are the lacunas in law that you can deal with, and then find out how your research paper will help overcome these lacunas, right? Then the second step is identifying your headings and subheadings. This is very simple, and yet most of the people skip doing this. Now, identifying your headings and subheadings is really important because it increases the scannability of your article. We'll come to scannability next. But identifying your headings and subheadings makes it easier also for you to write your articles. If, for example, you have taken the concept of bail, you have to write an introduction, the historical context. Then in historical, you can divide it into subheadings like in historical, you can divide it into subheadings like pre-independence era, post-independence era. Then you can take another heading of you can write international perspective of bail. Then you can write about UK, US, China, Japan. You can take hundreds of countries and you can write on that. And then you can write bail provisions in India, 436, 437, 438, 436A. You can write on them. Then you can write you can critically analyze them. Right. There are many things that you can do in one particular topic itself. I'm sorry, guys. Give me 1 second. So, yeah. So, once you identify your headings and subheadings, it will become easier for you to write a particular article. Okay. Why? Because now you know what you have to specifically search. Now, if you can see the subpoints and identify your headings and subheadings, what are the main categories or themes that your research will be organized around? That is, what are the topics that you will be discussing? Then, can you break down into smaller and more specific subtopics? Why is it necessary? Because it makes it easier for the reader to read and easier for the writer to write it. Then, how will organizing your research into headings and subheadings help you structure your finding and analysis? Very simple. Because once you have a particular rough structure of headings and subheadings, it will be easier for you to fill in your information, which is a third step. Making a rough and filling information. What are the sources you will use to gather data or evidence related to your research question? How will you organize and record this? And what strategies will you use to fill in the gaps in your research? Now, making a rough and filling information, these are the subpoints. Now you've identified your headings and subheadings. What are the sources that you can refer to, right? There are primary sources, secondary sources, and tertiary sources, which we'll get to next. So there are these three sources of law that you can use. You can use case laws, you can use statutes that you have, you can use commentaries, you can use textbooks, you can use journals, you can use research papers, legal dictionaries, encyclopedias. There are a lot of things that you can use. But to use them, you must know what is the thing that you're searching for and what is the issue that you're addressing. Hence, it becomes very important to first find out your headings and subheadings and then fill in information. Then comes revision and editing. Revision and editing is very important because once you write your article, you think, okay, I'm done. But you're not done. There is always scope for improvement, and we all have to, at one point or another, agree to that. None of us can write a perfect article in just one go. Now, it is very important to review and to revise your article and to edit your article at least once or twice. For that, what you can do is you can ask your peers for your help. You can ask your mentors for their help. You can ask your faculty members for their help when you're writing specifically a research article. I'm speaking of that. You can ask your faculty because it is important that your article or your research paper meets the academic standards. If it does not meet its standard, then there's no use of writing that particular article or publishing it. If there's no clarity in your writing, if there's no if the grammar is not right, or the author, that is, if any one of us who's writing an article is not able to communicate what they want to, then there'll be no use of writing that particular article. Because why we are writing? To help the reader understand law in a better manner and to address a particular issue. But how will you address an issue when your article or paper does not speak for itself? We do not want that. Hence, it is important that you revise your article and edit your article. Ask your mentor, ask your peers, ask your guides, ask your faculties, whoever you're close to, ask your friends for that matter of fact, कि यार एक बार मेरा article पढ़ो and tell me how I can improve it. Not everyone will take you seriously, but those who will, they'll definitely help you. And trust me, this help will go a long way. When you're returning with us, you can always ask your mentor. Since this is the research batch, I believe Paras is the mentor, and Paras is always there to help you. If you ever face an issue, ask Paras or ask your immediate supervisor there are many people who will be supervising you. So ask them for their point of view or their help, and they'll definitely help you. Now, points to remember when you're writing a research article or a research paper. Now, let's see. The length of article, the language and grammar, scannability, and explaining jargons. Pretty straightforward points. These are the first one is the length of the article. Now, when we talk of length of the article, it is important for us to remember that when we are going for a particular competition, say for example, or if we are going or if even if this research, if we're talking of a minimum of 2000 or 2500 words is the minimum word limit, I'd say. Okay, now when we have that minimum word limit, writing an article more than that word limit is fine, it's okay. But writing an article that is just, I'd say, 1000 words will not be enough. Now, say for example, you go for a competition or an essay writing competition. Let's take an easy one, an essay writing competition, and they say your article must be anywhere between 1000 to 1500 words. If you write 1000 words, well and good. If you write 1500 words, well and good. What happens when you write 2000 or 2500 words? The first instinct of the organizers is to disqualify you. Why? Because they're specifically given guidelines that your article must be between so and so words. Hence, it is important that you always ensure that your article is written within the particular word limit, because if it is not, then your article will get rejected. Specifically, I'm talking of competitions. Now, when you're interning with us, there's a word limit given. The word limit is a minimum criteria that you'll have to fulfill. Writing more than that is well and good. But at least try to write the minimum word limit of 2500 words, because anything lesser than that, we believe, is just interns lazing off and not doing their work. I'm being blunt here, and I'm sorry if that hurts someone. But yeah, always try to write a minimum of the word limit that is prescribed, because firstly, it is not just helpful for the people who will come and read your article. It is also helpful for you, because if you've joined a legal research internship, you'll learn something while you're researching. The more you research, the more you learn. So again, always remember to write your article in the given word limit. Then language and grammar. Now, often there's a tendency, I'd say, not just for the students, but even I have done this, so I'm accepting it now, that if I find something relevant to my article or something relevant to my topic, what I do is I copy it and I paste it in my article without giving any second thoughts. No issues. Most of us do that. And I also give citations. But what would happen in the end is that since I've copy pasted it, that particular, I'd say, word or paragraph from somewhere, or I have used it for some, or I have taken it from an article which is not in a language that I'm writing it in, then it doesn't make any sense. बीच का खिचड़ी हो जाता है, ऊपर का एंड का तो अच्छा रहता है, बस बीच में खिचड़ी बन जाती है. अब वो खिचड़ी नहीं बनने देना है हमें. क्यों? क्योंकि उससे हमारा जो आर्टिकल है वो एक काइंड ऑफ बुरा इंप्रेशन छोड़ता है लोगों पे जो पढ़ रहे हैं. It shows that the author has not taken enough caution to go through his or her article once again and to understand the particular topic. Hence, जब आप अपना आर्टिकल लिखो, that is why again revision and editing is important. Always ensure that you're following only one format. If you're writing in first person perspective, write in that. If you're writing in third person perspective, write in that. Do not mix up the two, and always ensure that your article is grammatically correct. Then scannability. अब scannability का point मैंने पहले भी बोला था. How does scannability come? Scannability comes in your article when you write headings and subheadings. You might have opened many blogs जहाँ पे आपने देखा होगा कि there's a table of contents जो आ जाता है अपने आप blog पे, and if you click on a particular topic, you're taken to that particular point, right? What that does, it reduces the time that a particular reader needs to go through your particular article. Say, for example, I have a meeting coming up relating to arbitration, and I need specific some cases on or I need some interpretation relating to Section 11 of the Arbitration Act. Okay. Now, say for example, I need that, and I'm just sitting on web, and I have only 10 to 15 minutes to find whatever is needed. I see an article where it is well written, however there are no headings and subheadings dividing the article into various topics and subtopics. What happens is I'll have to read each and every word of the article to understand it, and मेरे 15 मिनट खराब हो जाएंगे. मैं 15 मिनट में जहाँ पे 10 आर्टिकल पढ़ सकती हूँ, मैं एक ही में अपना टाइम स्पेंड कर दूंगी. Until and unless that article is 100% reliable one, or 100% something that is useful to me, मेरा तो टाइम वेस्ट हो गया. 15 मिनट ही है मेरे पास. On the second hand, I have an article जहाँ पे clearly Section 11 of Arbitration and Conciliation Act interpretation करके लिखा हुआ है. ठीक है. I click on that, I read the interpretation, I understand it. I go to the next article, same thing, I read whatever is needed. I skim articles. It makes it easier for the reader to skim your articles when you have headings and subheadings identified. Hence, whenever you're writing your article, even when you're writing your article with Legal Vidya, it's because your articles Indian होंगे publish होंगे तो कौन पढ़ेगा? Your peers will read, your faculties will read, we'll read, everyone will read them. It is on web, it is for the whole, available for the whole world, whoever wants to read it, right? Now, to ensure that it is easier to understand and easier to read, always mention headings and subheadings in your articles. And lastly, explaining jargons. Sorry guys, give me 1 minute. Yes, coming back to the fourth point, that is explaining jargons. Now, what are jargons? Jargons basically means complex words that we use. Many of us think, and even I used to think at a point, कि मैं जितना complex English लिखूंगी उतना बढ़िया article लगेगा मेरा. But ऐसा नहीं होता है. An article is good when you're able to understand it with one swift read, I'd say. An article is good when a reader understands it instantly. Now, since we're all law students or from law profession, yes, we'll use jargons, and sometimes, not sometimes, most of the times, I'd say there will be jargons in our articles. There will be legal maximums or Latin terms that we use. Like, say, for example, there's quid pro quo. Say, for example, there's volunteer outfit injuria. There are many maxims and terms that we will use as law students in our articles, right? But if we use them, it is important for us to explain it at least once, so that the person who is reading the article, because there's no guarantee that the person who's reading your article is from a law background. He can be someone from commerce, he can be someone who's not at all related to law, he can be someone, or he can also be a law professional, for that matter of fact. So, explaining jargon will make it easier for everyone to understand your article. If it is possible, try to avoid using jargons, but wherever it is necessary, explain those particular terms that you're using so that the person can understand it and he does not have to always go in search of dictionary, right? So explain your jargons, write headings and subheadings, ensure the language and grammar is in one format and not in 10 different formats, and ensure that the length of article is appropriate. Then this format is specifically that we want you to follow when it comes to writing an article with us. There'll be abstract, keywords, introduction, the body, and conclusion. Right. Now, abstract and keywords. Abstract is basically a section of your article, that is the first section of your article, which provides a concise summary of your article. It is basically 100 to 250 words, maximum 250 words. No abstract is more than 250 words. So don't end up writing big paragraphs for abstract. Abstract will outline your main points of the articles and why you're doing a particular research or why you're writing a particular article. Keywords. Now, keywords are specific terms or phrases that we'll use. And what we do is in keywords, we write the main, I'd say, concepts that we are, or main terms that we're using throughout our article. Say, for example, my topic is critical analysis on bail laws, right? So my keywords, don't write 10 to 15 keywords, 5 to 6 keywords does the job. Write bail, write section 436 or 437, 438, whatever you're talking of. Then you can write CRPC, you can write penal codes. So these already have made 6 keywords, right? What keywords does it? It aids in searchability and helps reader identify the relevance of your work. Hence, writing keywords is very important. Do not skip it. Now, when we talk of publishing your article, we often look for keywords that you have used in your particular article. So if you mention your keywords in the proper manner and we tag them, it is a 90% chance that your article will be in the top 3 searches on the web when we think of that particular topic. Then introduction. Introduction serves as introduction, basically, as the word suggests, it introduces your article to the reader. Okay, it outlines the purpose of your research and provides an overview of the specific legal issue or topic you're addressing. I'm so sorry for the noise, guys. Give me one moment. Yeah, I'm so sorry. Let's continue. So, introduction basically introduces your topic and gives a brief idea on what your topic is. And it outlines the legal issue that you'll be dealing with. Then in introduction, we have another sub criteria, that is the background. Now, in background, what we do is we delve into the historical aspect of a particular topic. Say, for example, we have a particular, say for bail itself, okay. But we will go into the legislative history of the topic and the historical background, and if there's any case law relevant to bail of the previous times, okay. We'll go there and we'll analyze all of them and write it in a background, because that section helps us build our article. So we have until now the 4 criteria: abstract, keywords, introduction, and background. Then we have the main body, where we'll have the main arguments. Then we have the supporting evidence and analysis. Now, what do you mean by main arguments? Main arguments basically is it addresses the particular issue that you're dealing with, that is your research question, and why you're writing on that. Say, for example, you are saying that bail provisions in India needs to be amended. Now you need to argue for that, right? So in the body part, you'll argue for why there is a need to amend bail provisions. For that, what you'll do, you'll add evidence. Now the evidence in this particular case are case laws. Then there's the statutes already existing. We can have foreign statutes, we can have Indian statutes, we can have many other things, such, say, for example, we have legal textbooks, we have commentaries, we have research paper. There are many things that you can use to support your particular argument, and then we'll analyze. So the analysis section discusses on how you want to interpret and apply the legal authorities. So for supporting evidence, you can use primary, secondary, and tertiary legal resources. And the fourth part is the conclusion, where you summarize your article and you also write certain implications. Now, summary is basically आपने जो भी लिखा है from introduction to your analysis part in the main body, you'll summarize that in a paragraph maximum, and then you'll write implications, or you can say conclusion, that is how your research or how your article has helped or has contributed to existing knowledge, or if there is any kind of reform that you want, or if there are any suggestion you want to make in conclusion and suggestion part. Right. So for the format, we have abstract, keywords, introduction, background, the main arguments, the evidence, the analysis, the summary, and implications. Now, we've talked a lot about sources. So what are the sources? I've said primary, secondary, and tertiary. So primary is the original source of law that directly establishes legal rules or principles. For this, we have statutes, regulations, case laws, treaties, decisions of various administrative tribunals, etc. For secondary, we have works that analyze or explain the primary legal resource. What are that? What are those? Those can be treaties, those can be commentaries, those can be articles, research articles, textbooks, legal encyclopedias, law reviews. If you have ever seen in your libraries, I'm pretty sure there'll be many law reviews there, okay, state-wise, even central law reviews. So those works are secondary sources. Then we have tertiary sources. These are compilation of primary and secondary legal resources that are made for general understanding, like legal guides that we refer to during our exams, then handbook, citers, and legal research guides. So these are some sources that you can use. Now, plagiarism. Plagiarism is one of the most, I'd say, important things you need to remember while you're writing your research article. The reason is very simple, because plagiarism is unethical and one must avoid it at every cost. How can you avoid it? Firstly, understand what plagiarism is. What is plagiarism? Does anyone, if you have any idea, let's turn off the PPT for once. And does anyone have any idea of what plagiarism is? Just write it down in the chat box. Copied content. Anyone else? Okay, copy paste, copying someone else's work without giving them due credit. Right. So basically, plagiarism is an act of, Chat GPT and all, yes, kind of, you can say that, Pooja, but not 100%. So plagiarism basically is an act of using someone else's work without giving them due credit. अब मान लो आप एक assignment कर रहे हो, group assignment मिली है आपको, आपने और आपके सारे ग्रुप ने काम किया, लेकिन ग्रुप में हमेशा वो एक बच्चा होता है जिसने कोई काम नहीं किया होता, ठीक है, बट वो एक बच्चा जाके असाइनमेंट सबमिट करता, बोलता सर देखो मैंने सारा काम किया, इन लोगों ने तो कुछ नहीं किया है, ठीक है. हाउ विल यू फील? Keep that feeling in mind when you're copying someone else's work without giving them proper credit. So basically, plagiarism is the act of using someone else's work, using someone else's literally work, or in your particular article or research paper, while without giving them due credit, as you have stated, most of you have stated. Now, what can we do? Firstly, understand plagiarism. I hope it is clear what plagiarism is, because there's nothing more complex to it. It is just using someone else's work without giving them due credit. What you can do to avoid plagiarism? Firstly, cite sources properly. That is, always give proper credit to the people or the scholars whose work you're using. Use quotation marks. Now, when you're directly quoting someone else's work or some text that some author has stated, use quotation marks, because it makes it easier for the reader also to understand that this is a work that is done by some other person, and you can refer to that person's original work if you want to read more on that. Then paraphrase. Firstly, if it is possible, avoid paraphrasing, but I know since it is not, while you're paraphrasing, use your own words, but do not change the meaning of the original author, what he wanted to say. Okay, write the paraphrased lines in your own word and in your own understanding, rather than copy pasting words and moving 2 to 3 words here and there. Don't do that. Read a particular article, understand it, and if you want to paraphrase, use your understanding of the work that that particular author has done. And even when you paraphrase, do not forget to give due credit to the author. Attribute ideas simply as the first, second, third, fourth point have stated. Give due credit to the authors. Reference facts. Now, facts are something, say, for example, I am saying that the earth is round, right? This is a known fact. There's nothing you can cite for that unless and until there's something else which I don't know about. Just saying it that as an example. But say for example, you're using some kind of data. Say you're writing a criminal related article जहाँ पे आपने NCRB, that is National Crime Record Bureau के डेटा को साइट किया, तो आपने जहां से भी वो डेटा उठाया है उसे आप साइट करो in a proper manner to ensure the authenticity of what you have written. साइटेशन इसलिए जरूरी है ताकि जो भी आपका आर्टिकल पढ़ रहे हैं उसको ये ना लगे कि इस ऑथर ने अपने खुद के मन मर्जी से कुछ भी लिख लिया. इट इज इम्पोर्टेंट टू एंश्योर द ऑथेंटिसिटी ऑफ योर आर्टिकल. हेंस if you're referring to any such data, any government issued data or any other data you have taken from newspapers or articles that are written, reference those. Manage your notes. Manage your notes basically means keeping track of all the sources that you have gone through throughout your legal research. Say, for example, I have gone to 10 sources. While I'm doing my legal research, I need to keep a track of all the sources that I've gone through. क्योंकि बहुत बार we unintentionally end up plagiarizing things because we have read so many things, we have an idea and we think that is our own. बट नहीं, कई बार ऐसा होता है कि आइडिया किसी और को होता है, बस हम अपने शब्दों में लिख रहे होते हैं. सो इट इज इम्पोर्टेंट दैट यू मैनेज योर नोट्स, कीप इट इन अ प्लेस सो दैट एट द एंड ऑफ योर आर्टिकल और व्हाइल यू सबमिटिंग इट, इफ देयर एवर you think कि नहीं यार ये तो मैंने कहीं और से पढ़ा था, मेरे को ऐसा लग रहा है, you can just open all your notes or open the things that you have reference to and you can check that. Then avoid patch writing. Now be cautious when rephrasing sentences or paragraphs from a sources. Again, similar to paraphrasing effectively, what you must do is you should use your own understanding and interpretation to ensure that you're not copy pasting from someone else's. Use plagiarism detection tools. Obviously, now we have the let's say luxury of internet and Google Baba, and there are a lot of plagiarism tools that are free of cost. So go to them after writing your article. Just upload your article there or copy paste whatever the scheme may be, and ensure that the plagiarism is in limits. Now, when you're interning with Legal Vidya, the plagiarism is a minimum of 10%, I believe, Paras. Please correct me in the chat box if I'm wrong. I believe it is 10%. So, use 10 stay in that particular limit only. Do not go outside the limit, because even when you write research papers and research articles, if for example for a journal or a competition, even then, if your article contains more than 10 to 15% plagiarism, generally is the accepted criteria. If it contains more than that, your article will be rejected. Then the last point is to seek guidance. If you're unsure on how you must cite, or if you're unsure on how you must check plagiarism, or if you have no idea on what can you do to reduce plagiarism, go to your mentors, go to your peers, talk to your peers, talk to your guides with Legal Vidya, talk to the people who are above you, the admins of your group who are handling you, and they'll help you in with this particular issue. That is it that I had to share regarding legal research and writing with Legal Vidya. Now, if anyone of you has any query, please write it down in the chat box.
Thank you so much, ma'am, for a wonderful session. The question from Saswati Paul: what is patch writing?
So, Saraswati, patch writing basically is, when you attempt to put someone else's work into your own words, but you fail to do so, and you end up thinking that, say, for example, मैंने बोला है XYZ, ठीक है, और आप अपना आर्टिकल लिख रहे हो, आपने YXZ कर लिया, words मेरे ही है, you have not used your understanding, you have not used your interpretation, you have just put the words here and there from my from whatever my idea was, and you have not given credit to me. That is what we mean. There are some of what are some of the plagiarism tools you can use? Grammarly, that is free. You can use Tupely Checker, that is free, and we'll also drop a link of few plagiarism tools in your WhatsApp groups that you might use for your research purposes. Those are free ones, and if your college gives you access to Turnitin kind of tools, you can use that as well. That is also one of the plagiarism tools. How that is a paid one. If your college gives you access, you can use that as well. So that is one of the tools that you might use. Small SU tools as well. Yes, thank you, Paris. Anyone has any other query? Is this a paid internship? The duration, firstly, Jia, is of 1 month, and it was informed, or believe it was written in the Google form, if not, my bad, that the internship is an unpaid one for a period of 1 month, a minimum. Yeah, we could say that they're similar things, Saraswati. And articles, when we cite any cases or commentaries, etc., should we cite then and there, or should we cite now? Pooja, just give me a second. I'll be back. Right. So now some people or some institutes, I'd say, they go for references as well as citations. Some only do with references, some only do with citations. Now I'm talking of when you intern with us, you can just cite it then and there itself. Say, for example, you've written Keshwananda Bharti was the state of Kerala. You can just cite it then and there itself. That's enough. You don't have to do the hassle of writing it in references in the end. Or what you can do is you might or if you want, you can just write the references in the end and exclude the citation. It's completely upon you. Do any one of the things, don't go for both of them. The topics assigned to us for article writing during, is it necessary to work over them? Now the articles are assigned by your coordinator and you have to work on them. However, if there's any other extra topic you think that you can write a good article on, you can consult or you can just drop a mail at Paris, please drop the Gmail wala mail ID. You can drop a mail there, and if the team approves, you can write on that as well. You're welcome, Saraswati. Does anyone have any other query?
Guys, if you have any other query, please write in the chat box.
Yes, we'll provide the recording. But however, it'll take a day to do so because we'll have to upload the same. So you'll just have to be patient for a day and then we'll upload the recording. You're welcome, Tosh. Any other query, guys? Yeah, if you do not have any queries, you can leave the session. Thank you all for joining. And Paris, over to you. You can end the session. And okay, there's an art question. If we have written an article before and not published, Yes, you can ask. We do publish articles, Pooja. Just we'll share a mail ID. You can just drop your article there. You're welcome. You're welcome, everyone. Paris, we can end the session now. Okay, I'm sorry. Instead of articles mentioned for us, okay, Pooja, that won't be possible, unfortunately. But if you have any extra articles that you want to publish, we can definitely do that for you. But the task assigned to you, as I've already said to Tush as well, you'll have to stick to those and do those. But if you have any other, if you have any other, I'd say, ideas or topics you think you can write on, we can do that. So those who are not currently enrolled in any university, so you have the freedom and liberty of using internet. There are statutes available there. There are case commentaries available there. There are uh, cases available there. You just have to type the correct keywords on Google and everything is there at your access. Rashid Khan, if I'm audible, just type the keywords and topic there and everything is there on Google. You don't need to refer to books, trust me on that. Everything is available on Google, and you do not even, I'm talking of the free sources itself, not even the paid ones. You're welcome. Roshan, if you wish to do so, just just drop a WhatsApp as a text to your group coordinator so that there's no such problem when you submit the task in mid of March. Since you're interns, there's no charges for publication for you all right now. It's free of cost. Write great articles and they'll be published with your name on the website. Welcome. Any other query, anyone? Minimum duration, yes, it's 1 month. You're welcome.
Thank you so much, everyone. Thank you, Sakshi ma'am, for such a wonderful session to given to our interns. I hope you all learn the meaning of legal research, different research methodologies, format of an article, and what are the steps to remember while writing an article. Now, I will also inquire you. Please join the session at 9 p.m. of the introductory session of the legal research internship. Thank you so much.